I'm Roland Adjovi, one of the 5 experts in the United Nations Working Group on Arbitrary Detention. I'm sorry that my course load does not allow me to attend this revelation of your case, but I hope that this introductory remark will help you understand better who we are and what we do, and more importantly, how your competition is going to contribute to our work. The Working Group on Arbitrary Detention has been established in 1991 by the Human Rights Council, previously known as the Commission for Human Rights. The purpose of creating that working group was twofold. First, in human rights, there are a set of treaties which states have to sign up for and ratify, and those treaties establish monitoring mechanisms. But states do not always ratify those treaties. It means these monitoring bodies do not have jurisdiction over all states in the world, but only those states who have ratified. Therefore, the UN had thought that an alternative mechanism will be necessary, which will hold every state in the world, or at least every state within the United Nations, accountable for human rights violation. The Working Group on Arbitrary Detention is part of that mechanism established and based on the United Nations Charter. The second element is the Working Group was established to protect people against political abuse, the use of criminal justice tools, the use of detention against political dissidents. And that's the purpose given to the working group. But arbitrary detention has gone beyond the political dissidents. And today, there are 5 categories where the working group has established practice that there is an arbitrary detention. It can be a situation where the detention has no legal basis at all. It can be a situation where a human rights violation, a human rights expression leads to the violation. For instance, if you demonstrate, and that's the sole basis for you to be arrested. It can be, and this is the largest category from far, any violation of your fair trial right, the due process right, during the criminal justice process could lead to violation and could lead to arbitrary detention. The working group has also jurisdiction to consider any lengthy detention of immigrants as arbitrary. Finally, if your detention is based on discriminatory principle, on a violation of certain key human rights, in any of those 5 categories, we could hold the state accountable for violation, for arbitrary detention. And the working group does 2 types of things. We receive individual applications from different sources, not always from the victim. On those applications, we do 2 things. Either we issue an opinion, it's a kind of judgment we issue, listening to the party who applied to us, questioning the government about the situation reported to us, and balancing between the 2 and making a final decision as to whether there is arbitrary detention or not. In individual case like that, if there is any health issue, any risk for the health condition or for life, we could issue what we call an urgent appeal, asking the state to take measure to prevent the harm to the victim. These 2 types of measure we issue, we have plenty of them. For instance, on the opinions, we have had about 1,000 since the working group was established, and we issue about 50 to 75 every year. For the urgent appeal, since the practice has been established, we have already issued about 2,500 of them. Each year, we issue about 300 of them, either unilaterally or jointly with other special procedure. The working group does a second type of things, which is country visit. The country visits are not a judicial process. It's the result of a dialogue with a government. The government invites the working group, asks the working group to come and visit and make recommendation for that state about the legal process. And that's a very constructive process where there is a communication, a continuous dialogue between the working group and the country until the visit occurs. And during the visit, the working group meet with officials of the government, visit place of detention, meet with people who are detained in those places of detention. And the place of detention can be both the classical place of detention, the prisons, but it can also be a health center for the mentally ill people. It can also be a private house if an elderly person is being detained in his or her own house. And the working group will look both into the legal framework of those detention, discuss with the officials on the practice of detention in the country, and based on its own observation as it moves, make recommendation to the state. These country visits are essential, are very constructive process, and play a major role in preventing detention in the long run. Very useful. However, states do not like them that much because the first type of measure scare them already. So far, since the working group has been established, we had about 40 country visits. The working group has never visited the United States and has engaged into a negotiation with the United States for a country visit. We hope that this will happen because the US could lead the way, offering an example of what should be done, but also receiving the working group could show the way to many other countries. Your exercise will be part of that process. Your exercise will help the working group understand better how things are done in the United States, what are the challenges, and you might have solutions which the working group could use. The working group in general is well perceived as an enforcement tool. Recently, the working group has been on the spotlight because of the Assange opinion. The opinion issued in the case of Julian Assange, the founder of WikiLeaks. And I'm sure you'll all have heard about it, heard the interviews, read the news here and there. One of the critical questions raised in that case is, first, are the opinions issued by the working group binding for the state? The two states concerned here were Sweden and the United Kingdom. It's very interesting that the question is being raised by those countries, especially the United Kingdom, which has often relied on opinion issued by the working group to criticize other countries like China, like Myanmar, where they will say those are authoritarian human rights violators because the working group has made an opinion against them. Why would those countries now dispute the value of the working group decision when they have used it in the past as applicable, as enforceable? That gives you an idea of the political dynamic around the work of the working group. And that political dynamic is far more effective when it comes to individual application, to individual complaining against state. While in the country visit, states have a unique avenue to avoid those challenges in individual cases because they embark on a dialogue with the working group, which help them improve the system and prevent arbitrary detention. The working group has a huge impact in terms of who has been approaching the working group. Everyone can come to the working group. The process is easy and very flexible. Contrary to the treaty bodies, you don't need to exhaust local remedy or domestic procedure. You can come to the working group at any stage, even without having seized the domestic judge. You can come to the working group without any other legal framework than the United Nations Charter. And the working group apply two major instruments. The key instrument, the Universal Declaration of Human Rights, which is applicable to everyone because it's customary law. But anytime a state before us has ratified another relevant treaty, we make reference to that treaty. The most common treaty being the International Covenant on Civil and Political Rights. Those are the key instruments the working group uses in its process, but it can use every other existing instrument as far as that instrument is applicable to the state. The working group, apart from addressing individual application either through opinion or through urgent appeal and running country visit to help the country, the working group can also do anything assigned to it by the Human Rights Council. And recently, the Human Rights Council has asked the working group to embark on an analysis of the legal principle, the existing legal principle, to provide a compendium of the rules which apply to arbitrary detention or to detention, to remedies in case of detention. And in September 2015, the working group has provided that compendium called Principle and Guideline for anyone deprived of his or her liberty. How that person should have access to a court of law to address, to challenge the detention condition, how often that should happen, and how this should happen whatever the circumstance is. Meaning, even during a time of war or even during a time of emergency, those remedies should still be available. That's the framework for the working group. That's what in the working group on arbitrary detention we do. And we are 5 experts with all legal background, no matter what some states, when challenged, could say about us. And we represent 5 regions in the world. I represent the African region. One of my colleagues represents the Asian region. Another one represents the Americas. One expert represents the Eastern Europe or Europe in general. And one came from Australia, represent that other part of the world. And each of us have a mandate of 3 years, renewable once. It means each expert on the working group can only be there for a maximum of 6 years. This is my 3rd year starting. And since the working group has been created, I am the 4th African sitting in the working group. Your work, your competition will help us understand better the detention condition in the United States based on your choice of the angle you want to tackle. Your work will help us master better through your view, through your ideas, what detention is in the United States. Your work, if successful, will also provide us with ideas on how, if ever we were to visit the United States, how we could help the United States improve the detention condition. Not only for the citizens of the United States, not only for the resident of the United States, but also for anyone crossing the United States, whether legally or illegally. All those elements will be highly valuable for us, and you are one of the stakeholders, the sources which feed the working group on arbitrary detention on a daily basis. We wish you good luck in your competition, and we hope that you will enjoy, and we will certainly enjoy both your ideas and your suggestion on how to improve things. Good luck, and we hope to read your work very soon. Thank you.